You probably spent a lot of time researching, drafting, and redrafting the pleading in your case. Nevertheless, you might need to change it later. In a motion for leave to amend, you're asking the court for permission to amend your pleading. The amendment can be to a complaint, an answer, or to counterclaims. For a complaint or counterclaims, you can add or remove a claim, or revise the allegations that support an existing claim. For an answer, you can add or remove affirmative defenses, or revise the admissions or denials. You could try to amend your pleading for any reason, but these are the most common situations leading to motions to amend. You learn something new from discovery. Your pleading is based on what your client knew at the time it was drafted, but documents or testimony from the other side might show that your pleading is inaccurate or incomplete. For example, if an email suggests that a misrepresentation you thought was inadvertent was actually intentional, you may want to add a fraud claim to the complaint. The facts change. For example, if the defendant commits more misconduct after the case is filed, you may want to add claims to your complaint. A motion to dismiss reveals a flaw. Suppose the other side moves to dismiss your fraud counterclaim because it's not pled with particularity, and you think their motion might be granted. You could amend your answer to add more detail. The governing law changes. A new statute or case decision could create a new cause of action, eliminate one of the existing claims, or support a new defense. Or you come up with a new legal claim. You might realize there's another claim that can be made that you didn't put in your initial pleading. Maybe you notice it while you're doing research, or your colleague suggests it in conversation. Whatever the reason, you can move to add it to your pleading, even if it could have been made before.